my time in your schedule today, and I'm looking forward to hearing it.
Great. Thank you very much. Good morning. Ask any lawyer, and he or she will tell you that the practice of law is the most noble of all professions. Lawyers defend the rights of the wrongly accused. They prosecute criminals whose behavior breaches the laws of a civilized society. The occupation of law remains very popular. 1 out of every 300 individuals is a lawyer in the United States. And the employment outlook for lawyers continues to be quite strong. Over the next decade, employment opportunities should rise by approximately 18%, according to the most recent survey. It's a bit ironic then, when we think about the profession of law, because there's perhaps no profession that receives so much ridicule by the public. Lawyer jokes abound. Why is that? Well, I've got a couple different theories, but I believe it has to do with the fact that most people just don't know what lawyers do. What do lawyers do? If you ask that question, you'd probably respond or hear a response that says, well, they go to courtroom. They go to the court and they argue. That's probably in part true, and it's based upon a very long tradition of oral advocacy. The public perception of what lawyers do is based a lot upon how the media portrays them.
I am confident that you gentlemen will review without passion the evidence that you have heard, come to a decision, and restore this man to his family. In the name of God, do your duty. In the name of God, believe. Tom Robinson.
Took a little bit of searching to find a clip that shows the attorney in a very dignified argument. More popular, more recent movies like A Few Good Men or even My Cousin Vinny don't always put the attorney in the most favorable light. But the public perception of what attorneys do is based in part upon how the media perceives them. As the media has shown, they spend time in the courtroom, and that's what most people think about when they think about lawyering. Oral advocacy, that's what lawyers call arguing in the courtroom. It is a big part of what lawyers do, and it has a very long tradition. How long? Well, I'm glad you asked. Our legal system has its roots going back to 1066 with the Norman conquest of England. A nobleman by the name of William from Normandy, which is now northern France, invaded the Great Isle to the north, defeated the Anglo-Saxon tribes, created a single unified set of laws, a court system, and that which has become known as the English common law. In about the 12th century, the jury system was introduced to the English common law, and ever since then, oral advocacy has been a very big part of lawyering. Arguing, presenting persuasive positions to the court, to the judge, to the jury. And so we do have a very long tradition as lawyers with oral advocacy. When the colonies were founded, the English common law found its way to North America, and we adopted the English system of laws here in the United States, and consequently, we have the same jury system and the ability of lawyers to argue cases on behalf of their clients. Fast forward to today. Today, less than 2% of all lawsuits ever make it to trial. Why the big difference? Well, if we go back to the late 19th century, there was this invention called the typewriter. And all of a sudden, rather than merely providing the judge with a handwritten list of authority, and then going into the courtroom and arguing for hours on end, literally hours on end. Now, lawyers could reduce their arguments to paper. And consequently, they could present their arguments to the court, and the court could read the arguments before ever hearing the oral argument on the case. The typewriter and office animation has changed the way lawyering is done. And so lawyers today are truly professional writers. When we talk about the law case, each and every step involves some type of written document that the lawyer has to prepare. Every lawsuit starts with a summons, and that's a pretty easy fill-in-the-blank kind of form requiring the defendant to appear in court and to defend the allegations against them. That is always accompanied by a document called the complaint. The complaint is a written document filed by the plaintiff, the party suing in the lawsuit, alleging facts which they claim give rise to a legal remedy. The facts are spelled out, at least are supposed to be spelled out clearly and one per paragraph, so that when the defendant receives this piece of paper, their attorney can file the document known as an answer, another written document responding to each of the allegations paragraph by paragraph in the complaint. The complaint and answer together are known as pleadings, and they're just yet another example of the written work that lawyers perform. Now, if the defendant doesn't file an answer, then the plaintiff can ask the court for a default judgment, another form, another document filed with the court, and if there's a no-show, then the plaintiff wins by default. Most times, however, the case proceeds to the step known as discovery. And this, contrary to TV shows about the lawyers, is the part where individual lawyers can find out everything the other side knows about his or her case. They file written questions, dozens and dozens and dozens of written questions, asking for facts, asking for information. Those are known as interrogatories. They can also then take live testimony, as known as depositions, and also get documents by means of a production request, so that they have not only the information, the testimony, but also any physical evidence that might exist that's relevant to the particular dispute between the parties. At some point in the litigation process, one or both of the parties can ask the court to dismiss the case in its entirety, either because the evidence fails to prove the case or the evidence provides a defense. And if the evidence is uncontroverted, then the judge can decide the case on its own. This is where typically written briefs are prepared, supporting the motion for summary disposition, and the oral argument takes place, where the court entertains the arguments in the courtroom like you kind of see on TV and what you're kind of familiar with. If that doesn't work, then you go to trial. And at trial, there are numerous documents that need to be filed in advance of the trial, and you go to the actual, have the witness on the stand, testimony, cross-examination, the things you're probably most familiar with as a layperson. And of course, if that doesn't work, the whole process starts all over again with the appeal process. And more documents are prepared for that next step of the litigation process. So what we have then, in effect, is that law firms, lawyers, as professional writers, create a tremendous amount of written material. The documents that a small law firm produces would make even a small publishing company envious as to the volumes of material that take place. I personally, on average, spend almost 6 hours a day writing, analyzing, sitting at my computer terminal, putting my first draft down, revising it, editing it, putting it away, starting another project, coming back when my mind is a little fresh, looking at it again, and editing it even more. Sound familiar? The same kind of stuff that you do when you write a good paper. So, lawyers as professional writers, let's talk about some details. What do they write? How do they write? In addition to the steps of the litigation that we talked about, these are just a few of the other things that lawyers will write, the documents that they'll prepare, all for purposes of the court presentation. But it doesn't end there. There is even more documents that the lawyer has to write. In addition to all these court-related documents, there's a tremendous amount of documents that are of a non-legal nature. They're talking about the subject matter of law, but it's not going to the court. Communications with our clients, communications with opposing counsel, memorandums of law, other types of written documents that aren't designed to go necessarily before the judge or the jury, but in fact still address the legal issues that are presented in the case. After all, as a lawyer, you're a business person, and you have to make sure that your client, the person to whom you're selling your services, is happy. And one way to keep them happy is to keep them informed. And so you inform them about every step of the litigation process. And so the writing, although not legal, like argumentative, that goes to the judge, still has to be legal as in it's addressing what's going on and the issues that we are facing in the particular litigation, but in a more passive tone. All right, so you've got this tremendous amount of writing that lawyers do. You say, okay, I get that. What about the actual writing, the actual words, sentences, and paragraphs? Well, when you think of lawyers and you think of writing, another myth that's very common is what I have up here. This is a transcript from an actual 1785 lease. And I don't know if you can read it too well, but it's lawyer pig Latin, what you probably refer to as legalese. Witness that the said Mark Ransford for and in consideration of the rents and covenants hereinafter reserved and mentioned on the part and on behalf of the said Arthur. Lawyerese, that's how lawyers talk? No, that's not how lawyers talk. Is that how lawyers write? That's not how they should write. Why do you have legalese? Well, we can go back and thank William the Conqueror for that, because back in 1066, when lawyers were preparing legal documents, they had two audiences. And as any good writer knows, you have to write to your audience. They had the English audience and the French audience. And consequently, they used pairs of synonyms, one that had an English root and one that had a French root. And consequently, you mucked up all the writing by putting all these dual phrases in. That's legalese. And that, unfortunately, remains the perception of what lawyers do when they write. And to some extent, that's what some lawyers do because it makes them sound a little bit more important than they really are. In order to write well as a lawyer, there are commonalities between what lawyers write and what the general public writes. And we can take a look at it in the sense of style. Yes, lawyers have to follow some rules. In addition to the general grammar rules, there are some stylistic rules that lawyers have to follow. So if you're used to writing a paper and following rules, things aren't going to change if you become a lawyer. For example, these court case captions, they have to follow a certain format, a certain setup, a certain rule as to how they're presented. Each court case has to identify the jurisdiction, the court that is hearing the matter. The parties have to be identified in a particular way with the judge and the case number, and then the attorneys below have to be identified in a precise manner. Whether by convention or tradition or court rule, there are certain ways that lawyers have to write. There are also, of course, other stylistic rules that lawyers follow, much like you would follow. There are certain rules you have to follow when you prepare a bibliography or a footnote. Well, when citing authority, because lawyers cite legal precedent, court decisions that occurred in the past that have a binding effect on the disputes today, they have to use a particular type of citation when they write. So there has to be the right commas, the right semicolons, the right abbreviations that are followed. So you can never quite get away from the rules of writing. But that doesn't mean that writing alone is stuck just in this formalistic fashion. There are other ways that lawyers write, and much like your writing, can be thought of as a genre. One particular genre, and the one you'd expect to have from a lawyer, would be persuasive or argumentative writing. That's a very common way to present an issue. And one of the traditional ways that lawyers follow their own 5-paragraph essay format is an IRAC method, where they identify an issue, they state what the rule is, they provide an analysis, and then they give a conclusion that will favor their case. And of course, the other side's doing the same thing. So the judge has to take a look at both of those legal writings and see which is the most well-reasoned, most persuasive, most logical. So it typically always comes down to how well the briefs are written to decide who wins the case. But of course, legal writing in reality is not limited to just those court documents. You many times have to write memorandums of law, whether for a senior partner, your supervisor in your law firm, or for your client. You have to take that legal argument and water it down a bit to present it to someone else who might not have any knowledge of the area of law whatsoever. And therefore, you take this memorandum of law. It's not so forceful as a persuasive piece, but you're again presenting factual information, legal precedent, arguments in favor of your case for, in this case, a memo to a client, explaining the situation in the law that would apply in the facts that are before it. You've got emails. Emails are big now in the legal world, and they've kind of taken over from the legal memorandums, the memorandums of law, and so we now communicate with our clients on an instantaneous basis by providing factual information and historical information through the email process. So another way that lawyers will write, not just to the court, but to their clients as well. Like any good writing, you have to keep in mind, who is my audience? And sometimes the audience is the judge, formalistic, rational, logical. Sometimes it's the client, maybe a little more emotional, have to be a little more sensitive in how you present the information. Can't push them around too much, have to make the conclusion appear obvious without telling them, because clients love it when they come up with a solution themselves. And sometimes it's going to be to other lawyers. And contrary to public belief, lawyers are people too. And there are ways to tug at a lawyer's heartstrings, just like you tug at anyone's heartstrings when you're writing a good piece. So if the audience perhaps is, in this case, an arbitration panel, 3 lawyers that have been selected by the court to independently hear the matter, to help the parties kind of decide if they want to settle the case, well, you can take a different genre. Rather than being so formalistic and legalistic, you can take on a sort of a novelistic approach. You can tell a story. You can be creative. You can use first person. You can use dialogue. You can make a story which can be just as persuasive, just as strong, as when you're making that very formal legal presentation. All right, let's talk very briefly about some of the skills that are necessary for individuals who wish to be lawyers. According to the American Bar Association, which is the professional organization that governs lawyers across the country, there are certain skills that students should have, or at least begin to develop before they enter law school. Those skills include the ability to organize and manage a lot of information. How many students in this particular audience are in the English department, have taken English courses? A couple, okay, a few. How many have taken more than one English course at a time? A couple unfortunate souls. What happens if you have maybe 3 or 4 English courses at the same time? How's your workload? Pretty heavy, huh? Lots of information. The ability to gather that information, to organize it, to create tasks for yourself, and accomplish those tasks is a very important skill that lawyers have to have. And law students, people going to law school, need to develop that if they wish to pursue a legal career. Critical reading abilities. Don't need to say very much about that. The ability to read something, to be able to analyze it, to be able to dissect it, pick out its meaning. Important skill for lawyers, a skill that one obtains through taking courses in literature and English. Analytic and problem-solving skills. Now that you've got the information, you've been able to collect that vast amount of material, you've been able to read it, dissect it, and understand it. Now you have to start to break it down, put it into bite-sized chunks, make it easy to understand so you can argue either for or against it. Same thing when you analyze a particular piece of literature. You have to take that big piece, break it down, look at it, break it into bite-sized pieces, and then start to structure your own argument in response to whatever the query or the writing prompt is. General research skills. The much feared research paper in the English department. Well, lawyers do a lot of research because every type of argument that they face has probably already been solved before. And so they have to look for that legal precedent, that prior case decision, which gives them some rules, at least some parameters by which they can argue to the court how this court should decide their case. So the ability to do research is an important skill that law students and lawyers need to have. Of course, oral communication skills, we talked about that. That's the oral advocacy portion. The ability to do public speaking is an important component of being a lawyer, but not all lawyers, quite frankly, go to court, and not all lawyers do a lot of public speaking. Those that do not spend all of their time typically doing the writing. And so writing skills, probably the most important skill for lawyering, whether as a law student or as a practicing lawyer, because lawyers are professional writers. And those are the individuals that, in fact, do the best, because the arguments that they reduce to paper usually are the arguments that are going to convince the judge one way or the other as to how the case should be heard. Most judges, by the time you get into the courtroom, they pretty much have their mind made up. They'll ask a few questions, sometimes to be polite, sometimes because they just don't understand the arguments that are being made, because they're poor arguments, because they're poorly written, just to sort of keep the lawyer in check. But generally, they already have their mind made up when the oral arguments take place. So, if we can sum it up, if we can talk about what it takes to be a lawyer today, we can talk about good writing skills. That's the paramount thing that lawyers have to do. If we could compare good lawyering and writing skills that a lawyer has with the general skills that people have, a simple things that we can have as takeaways. Less is more. They do call it brief for a reason. A legal document is referred to frequently as a legal brief. Unfortunately, most legal briefs are anything but. The better selection of words, short, concise words, small sentences, precise paragraphs, typically convey information in a much more forceful and dramatic way than long sentences and paragraphs and words that run on forever. You lose the reader. Good transitional phrases to focus their attention from one idea to the next, from one paragraph to the next. It eliminates the possibility that the reader, the judge, or in your case, whomever your audience is, will have to go back and reread the prior information to see how is this flowing. It gives you a better flow to the paper when you use good transitional phrases. Active voice, rather than the passive voice. An active voice is a very effective tool for lawyers and for writers in general. Use that first-person active voice. You'll end up having shorter sentences, which goes with rule number 1, and you'll have less words that just sort of muck things up and get in the way. Limit your footnotes. Lawyers have tended to love footnotes. And sometimes in the lawyers' briefs that I get, the footnotes run half the page. Footnotes are like the doorbell ringing on a honeymoon. And in the immortal words of Forrest Gump, that's all I'm going to say about that. And lastly, be creative. Just because you're an attorney doesn't mean you can't be creative. Just because you're an attorney doesn't mean you have to give up perhaps the love that brought you to being an attorney in the first place. Your love for the English language, your love for English literature. You can incorporate creativity in legal writing. Yes, you might be writing a persuasive or argumentative piece, but you can be creative when you do it. And as a result, your writing will be better. It will stand out from the rest, and it will make you a more successful attorney. So, in conclusion, contrary to the advice of well-intentioned but misinformed mothers everywhere, just because you can argue doesn't mean you can be a good lawyer. You have to write well, too. Thank you.